Afternoon and good morning, everyone. Welcome back to the Blind Press YouTube channel and coffee stream episode 527. Sorry I sound like this still, but I'm still dealing with my head cold, so that's just what it is. I am on my own today. Mr. Skeptalk had to be chauffeur, so he is not available today, but he will be with us on Saturday for Star Trek. So today we're just gonna do a couple of articles, and then we're probably going to end up stream sniping Nick Rekieta because we've got I'm not sure how much longer the psychiatrist is gonna be on the stand. So and she's really been pissing me off. It's Amber Heard's team is now presenting their case. Johnny Depp's team rested Monday afternoon, I believe, or yesterday morning. I think it was yesterday morning. So now it's Amber Heard's side's turn to present their case, and this psychiatrist that they have, she's literally a professional witness. She only works with battered women. She has basically posited that only men are abusive towards women. The only way women ever get violent back in relationships is if they're provoked. It's bad, and Johnny Depp's team is cross-examining her right now. So you know what I might do is stream snipe first and cover some articles later, because I really wanted to talk about that. Like, this woman, not only does she only do work for battered women, but she's constantly contradicting herself. She is just it's horrible. If I was on the jury, I would be like, this woman is a terrible witness. She should be impeached, honestly, because of her bias. And she also is making up words like diminished instead of diminished. Or what's the other one? There's a lot. Reelection instead of recollection. Symptomatology. She said that one multiple times yesterday. Instead of symptomology, it was symptomatology. She also was saying that she doesn't diagnose women with personality disorders. It's like, what? It's insane. This woman is crazy. So let's quickly take a look here. We're gonna try to get this loaded up here, because I don't want to miss it. Because I'm not sure how much longer they're going to be cross-examining her. But there's a lot of things that she's said about Johnny Depp that, like, there have been no corroborating evidence to back it up. Like that he apparently sexually abused her. Like, there is a lot of stuff that this woman is saying on the stand that has never been said before now. So it's very, very interesting to see what's going on here. Sorry, I'm just trying to get to the live stream here. There we go. I want to watch the thing. Let me watch the show. Let me watch it. Yes, I want to watch the live stream. Let me watch the live stream, please. Ugh, screw it. I'll just DM myself the link. Let's see here. Where is it here? I'll just DM myself the link instead of trying to find it. Here it is. Okay. Copy link. There we go. Where? Oh, I'm not. Don't have Twitter open. That's not helpful. So yeah, this psychiatrist lady, I don't even know if you can call her a psychiatrist. I feel like she's about 30 years behind in her psychiatric ideas. And I have no idea who you are, so go away. Yeah, somebody just tried to call me. So, yeah, I am not going to talk to them. Okay, let's get this going here. Do. You sent a link. Yes, I know I did. Hey. What the hell? I hit the send button. Oh, I didn't hit the send button. Derpa derpa. There we go.
And talk about domestic.
Okay, now let's get this shared here. He's still on the stand. This is good. So, yeah, I want to show you just how batshit insane this doctor is. I can't believe she's actually a doctor. They will give PhDs to quite literally anyone, apparently. And she has such a good job at being a professional witness that she's got a Madison
violence in
Avenue
a legal
office.
setting. Okay, thank you. And that's been moved into admission. That's been moved in, correct?
Yeah.
Okay, well, let's go to the one that I don't think
redirect?
was 1242, please. Tom, if you could bring that up.
Oh, I'm still annoyed.
All right, and is that just
that's
one page too?
big,
How many
big
pages is that
loss.
one? Okay. Do you recall this
We are on
presentation,
redirect.
Dr. Hughes? Yes, I do. Okay. Could you please just, well, I'm going to move the admission of plaintiff's exhibit 1242 first of all.
Any objection? All right, 1242.
And could we publish it to the jury, please?
I like doing
And Dr.
this
Hughes, could you
because I
please
like
tell the
Nick's
jury, explain to
commentary.
the jury what this presentation entailed?
Kaufman.
So I was asked by the head of the Kings County Bar Association to give a presentation about intimate partner violence, domestic violence, and how psychological experts can be of assistance. This was just
And
because
how
of how
you
Brooklyn
only
is a
represent
bar
women
association that was attended
talk
by
about how men
many of
are
the
only
prosecutors from the
users.
Kings County District Attorney's Office, as well as defense attorneys. And as I stated before, this presentation was about how to really understand cases of domestic violence, how to understand what if she drops the restraining order, what if she doesn't call the police, what are the myths and misconceptions
Notice how
about
she's only
intimate partner
saying
violence.
she.
And when she uses force, what does that mean? How do we understand that? How do we evaluate for that? So again, without seeing the rest of the presentation, I believe that was the thrust of this presentation.
No, what do you mean you gave the presentation? You should know what it was by seeing the front page. You gave it. Also,
Okay, great. Thank you. Now, you
Also,
testified about
you are so
the notes you
biased.
took and
You
the
should have
notes
been
you
impeached.
reviewed, and you were asked about some limited questions on testing. I'm going to ask for Defendant's Exhibit 1434.
so this is what Nick's chat calls the cat lady lawyer.
You're gonna do that when you
No, oh, no, no.
Okay.
Will I be doing a
Oh,
review for Don't
we need
Breathe too? If I can
Thank you.
find
Thank you,
it,
Sammy.
yes.
Mm.
But you were doing a fine job, Tom. I didn't mean to take it away from you. Thank you, Michelle. Dr. Hughes, is this your CV?
Please tell me.
Yes,
we're
it
not
is.
All right,
having
I'm
a
going to move
Johnny
the
Depp
admission
pity
of
party.
Defendant's
What do you mean a
1434.
Johnny Depp pity party? He's
You're out of completeness. They've got all the other records in here for Dr. Hughes. I'm trying to see completeness.
Yeah,
I'll sustain the objection.
we're
Okay.
watching
Let's go
how
to Defendant's
bad
1435,
this
please.
doctor is.
So you just tried to move her curriculum vitae into evidence, but that's a hearsay
Now,
document.
Dr. Hughes, you've testified about the different
I'm not sure what you mean by a pity party.
testings
about Johnny
that
Depp. I
you
mean, it's
administered,
clear
and this
he
is
was
one of the ones that I
abused.
believe you testified to earlier, correct?
That's correct.
And this
Oh,
is the
thank you.
DSM-5?
This is the clinician administered PTSD scale for the DSM-5.
Okay. I'm going to move the admission of 1435. Any objection?
Well,
so the
no,
reason they were trying to go to they went to sidebar was to
the
try
point
and get.
Sith, is that
Has a lot of other documents.
when you engage in
It's not the CAPS,
mutual
it's the
abuse,
DSM-5.
you cannot turn around. and
But she
blame the
administered all
victim.
these tests, Your Honor, and they
Hold on
can't,
one
for
second.
completeness
And
of
that's what
record, they
she's
can't put
doing,
in
and
partials
she's the
and
one
then not have the
Johnny
rest
was
of it.
willing to
Well,
settle
I mean,
in the divorce.
We can.
There was no objection to when they put theirs in.
I would
Now
say,
they're objecting to you.
Wait.
I would say rule of completeness, Your Honor, Rule 2, Virginia Rule
we
2:106.
missed something.
That they can't just put a partial in and then not have the completeness of the testing in the documents.
Where they put their test in. Now you want to put more tests in, correct?
Correct.
That's not completeness.
That's not a completeness argument then. That's just a different test.
Well, it's
but
also,
what's the objection though? That there's, okay, all right, I'll sustain the objection.
all right, well, then we'll go for the other ones. You did the TSI. What, before we go on to the others, let's talk about,
But
could
my
you
point
please
is that
tell the
when you
jury what you
engage in
administered in this
mutual abuse with
DSM-5 and why
somebody
this
and
is significant?
that somebody in the divorce settlement agrees that, yeah, we were both assholes
Sustain.
and we need to part.
Can you tell
because
us why the
we're both
DSM-5
assholes.
is significant that you
then
administered?
cannot turn around.
So the
3 years
DSM-5 is the
and write an
Diagnostic and
op-ed
Statistical Manual
about how he
for
brutalized you
psychiatric
and
disorders.
how
It's published by the American
you are
Psychiatric
some sort of
Association. That's where it has
hero
all the
slash
criteria and all the
martyr
information
for the
for
cause.
our major mental disorders like
and
major
defame-
depressive
and
disorder
defame
or
their
panic
character
disorder
like
or
that.
PTSD.
And that's why he's suing.
What the CAPS is, the clinician administered PTSD scale, is it follows all of that criteria that's in the DSM-5 so that you can make a very accurate diagnosis.
And what, if any, diagnosis did you make as a result of this DSM-5?
So not only on this, I mean, this instrument can stand alone where she meets PTSD criteria just by virtue of this instrument, pardon me, but also the other testing that I gave where she had elevated scales on PTSD measures, which correspond with the DSM-5 symptoms of
Okay,
PTSD.
but-
So there were multiple measures that are consistent across time that she meets criteria for PTSD.
Thank you, Dr. Hughes. Now, you were also given 1 page of the scoring on the TSI 2 and 1 page with respect to the PAI. Do you recall seeing that?
It wasn't the scoring, they were the critical items on those respective tests.
Okay, well, I'm going to ask to bring up Defendant's Exhibit 1858.
Let's see here. So yeah, this is this
Which is-
doctor.
the full PAI. And was this the actual testing and scoring?
Yes, this is the profile, the scores that are generated from the 344 questions that Ms. Hurd answered on this test.
And what were the results? What did you determine based on the testing of this PAI?
Well, that the results were valid and reportable. There was no evidence of exaggeration or malingering on this test, and there were significant symptoms that correspond with traumatic stress and post-traumatic stress
But
disorder
how do you-
symptomatology.
And I believe you said again that there was no elevated scores. Can you explain to the jury what you meant by that?
Objection leading.
Huh.
Overruled out. Go ahead.
So elevated
no, that's
scores
not
are
good.
a
Sorry.
way that we get to know where
Sorry,
a
dude.
cutoff is
I
to
know
say
you're
that
trying
something
to
is
help your
clinically
client, but
significant.
that wasn't the
And that
leading
follows
question.
very standard statistical principles. So when a scale is elevated, it means that we have sort of greater confidence that this individual endorsed a lot of different symptoms that make this scale relevant, and then we want to figure out why that person is having an elevated score.
I've got to run, boys. I'll try to come back later, though.
Anxiety.
See
It
ya.
gives us greater confidence
If
that,
it happened
this
in a
person's
trailer
maybe
park, nobody
reporting
would care,
depressive
just saying.
symptoms
But
like
the
people who
thing
are
is
depressed.
that
And what would
I
constitute an
I
elevated
get
score?
where you're coming from,
Well,
but
on different tests, it's
men
different
have
things.
to start
Certainly on the
somewhere,
PAI,
right?
it doesn't follow
Yes,
linear
he's
T-scores.
got
It's a little
the
different
money to
statistically.
back him up,
So you have to
but
look at it differently.
men
But certainly,
have to start
it's usually
somewhere
about a T-score of a
to get
65, and on some it's
their
a T-score of a
stories heard.
70, which is a T-score is a normative curve, is a way of allowing us to
That's all.
compare people's scores, comparing your scores to the normative group of scores.
I mean,
And would it be at all helpful to have the entire
there would have been a
test as
time,
opposed?
straight cis male, where we could have said the same thing about a rich woman, where, the only reason she managed to get away from her husband in a divorce was because she was rich enough to afford a lawyer to, kind of wiggle waggle the way through divorce, because it was a hell of a lot harder not that long ago for women to initiate the divorce proceedings. So, I mean, we could have said I'm sure there were some high profile divorce / nasty lawsuits involving rich celebrity women. And I'm sure there were a lot of the same sentiments. If this was a poor woman, nobody would care. And now look at how skewed things are. And hopefully, although Johnny is a celebrity and has a lot of money behind him, maybe this can be some way of helping men understand that there is hope.
To a one piece of paper or one page.
Well, certainly you cannot tell the entirety of how the symptoms that Ms. Hurd endorsed and the scales were elevated just by the critical items.
All right, I'm going to move the admission of defendant's exhibit 1858.
Objection hearsay.
And this is the completeness, Your Honor.
I'll sustain the objection. Next question.
Let's bring up 1859.
How'd you lose that one?
Yeah, how did you lose that one?
And this is, you were shown one page from the TSI-2, the Trauma Symptom Inventory 2. Do you recall that?
Correct.
Okay. What is the significance of the TSI-2 exam, the full exam?
The trauma symptom inventory is
You
a
have
test of
established the
common symptoms
significance
of
of all of these
post-traumatic stress
things
disorder
in
and
your,
related traumatic symptomatology.
direct.
And on this score, she had, elevations in intrusive experiences, which is the intrusive component of PTSD, where thoughts or memories or feelings come into your mind when you don't want them,
Yes, that's
accompanying
what happens
distress,
when you
and
make
then the
up
defensive
stories.
avoidance, doing many,
you
many
have
different
to
things to
always
push
think
it down,
about
to
them
try
so
not to
that
think
they
about it, to
stay
try not
fresh.
to talk about it, so that you don't get upset. And she also scored high on a scale of relational avoidance, having difficulty feeling close in relations and relationships, not only intimate relationships, but friendships as well. And that's a related trauma
Except
symptom that individuals
There's
have
lots of
after having
witness
sustained
testimony that
an
Amber
interpersonal trauma
is
like domestic violence.
got quite a social life.
And would it be helpful to have the full exam as opposed to one page out of it?
Are you just going to hearsay
As with
object this
anything,
one too?
seeing an entire profile gives one more information.
Your Honor, I'd move the admission of Defendant's Exhibit 15 for 1859,
Objection hearsay.
and I would argue the
If
completeness
we could
rule
approach
again.
for this.
Objection hearsay, yeah.
Well, the judge just sustained the exact same objection with the exact same arguments for another document. So I would think by logic, she needs to sustain this one.
Hopefully.
Now, maybe there's another rule, another exception to hearsay that she could try, but it didn't work on completeness on the exact same scenario with a slightly different, with a different test, but the same set of facts.
Yeah.
So if the judge were to allow this one, that'd be very weird. Real quick,
Yeah,
why they went to
PTSD.
sidebar earlier, guys. Amber Heard was, I believe, arrested for domestic abuse in her prior marriage
Yes.
with Tasia, whatever, that they were talking about. He had asked the question about that. He was trying to open the door on introducing the jury to that arrest for domestic violence.
Yeah.
That's why it was critical for them to get it, and they
they
lost
lost.
it there. They can
Now,
still try to
Dr.
impeach Amber
Hughes,
Heard with
you
it,
were asked-
but it would have been great here.
You were shown a couple of finger pictures of Mr. Depp,
That objection was sustained, by the way.
Yeah.
and I believe you indicated those were shown to you, and I think you were asked if these were severe injuries, correct?
Correct.
All right. Did you have any understanding of the cause of those injuries by
Oh,
Mr. Depp?
Yeah. And their
I do understand that
assertion
there's
is he
competing
cut his own
accounts of
finger
what
off.
happened, for
All
sure.
right. Let's bring up Defendant's Exhibits 373.
They're saying that Johnny cut his own finger off.
Gates of Above says, if two gay guys in a relationship get into a fight, is it domestic violence or just a fight? Also, here's to your fund for getting that new license for YouTube. Thanks.
Your Honor, I think this is already admitted.
We're only
According to
gonna
this
do about
one, they
5
would
more
both be the
minutes, and then we're
perpetrators
gonna
of
move on to
domestic
the
violence,
three.
I can mark
and there
it,
would be no victim.
but it's not admitted yet.
I think there was
Unless
a
it's-
version of that. If I may,
I don't know that.
Your Honor,
I can just tell you that 373 has not been admitted into evidence.
Your Honor, it's not redacted, and I don't believe it's been admitted.
the part I'm trying to admit is in another exhibit, so let's go it a different way. We'll take that one down. Let's go with 398.
398 redacted isn't evidence.
That might be the one.
That might be the one.
That might be the one. You know you have too many exhibits
is
when
it?
you're like, which exhibit do I
All
need?
right. If you could blow that up.
Good Lord.
Frederick Little, hey Nick, great
I
coverage
think
of the
we're
trial so
looking
far.
for-
Also, happy Star Wars Day to you
No,
in the
he's
chat.
too
May the
much of a
4th be
pussy
with
to
you.
cut his own finger off. Well, no, the
There we
other
go.
thing is he says, why would I
You can
cut my
blow
own
that one.
finger off when I love playing guitar? And I
Does Mike
still have a
Tyson do
band and I
cameo?
go on
Email
tour, which,
From Mr.
you
Depp
know,
to
another
David
good point.
Kipper, your understanding was that was his doctor, correct?
Correct.
Okay. And then I'm going to draw your attention to the last part of this. And this is on 3/19/2015. Thank you for everything. I have to figure out how to do this.
Why
I'm
is she
missing
asking her
controls
opinion on this?
Yeah.
Thank you for everything. I've chopped off my left middle finger as a reminder that I should, thank you, Your Honor, that I should never cut off my finger again. Do you see that?
Yes, I
That's a
do.
fuck.
Okay,
We've
so that's
already
Mr. Depp
established that
admitting
that's
that
a
to Dr.
joke,
Kipper.
dude.
The finger he cut off is on the right
3/19/2015.
hand.
Objection leading.
Okay,
I'll sustain the objection next.
okay,
Yeah.
that's fine. I'm good with that. Let's go to.
Oh,
My
I'm
left
glad
finger,
you did
it was a
499.
joke.
I'm very
That he's
glad
chopped
you're-
off his left so he would remember to never chop off another finger again. The one that got cut off was on his right hand.
Yeah.
And Your Honor, I believe this one is in as well, or is it the
It's a
redacted?
redacted one.
Yes, that's the
Okay.
one. Thank you. And then if I could draw your attention, this is a text message from Mr. Depp to Aaron Falati. We talked
Why
about
are
her
we
earlier
showing
on 10/31,
text messages
2015.
to
And
her?
it says, this is the second time he's held off giving me my meds by blackmailing me into seeing him. The first time I had just chopped my finger off. Do you recall seeing that as part of the documents that you reviewed?
I believe I did.
Okay, thank you. We can take that down.
We've established
Now, you were
he speaks
also
in metaphor.
asked to listen to an audio tape. And it's plaintiff's 343. I'm going to, and you recall listening to that audio tape at some point as part of your review?
Yes, I do.
Okay, I'm going to now pull up that same audio tape from the same date, and I believe that's June 2016. And if we could go to, and we're going to have a few different ones, so hold in there with us. We're going to start with 2 minutes 40 seconds 00, going to 2 minutes 40 seconds and 21.
So like literally 20 seconds.
Knocking on the door. I don't
Because
get
that
why
is a
one
fucking
informs the other.
irrational and violent fucking maneuver.
How
So
does
a
one
man would
inform
want
the
to
other?
get out of that area so that he doesn't get so fucking angry that he actually does pop the fucking wife.
That's one informed the other.
Oh. Go home and listen to the tape.
How does that show that he's the bad
Now,
one?
that was just before the punching, hitting that was played. Do you recall that?
Just before she
Objection
struck him.
leading.
Well, the tape recording that you listened to was at 2:46:01 to 2:47, 2:47:20, and that was 2:40
Objection leading.
to 2:40:21,
She wouldn't know that.
correct?
I
How would
understand.
she-
Objection leading.
Okay, now let's go to after that.
Overruled, go ahead.
Thank you. Now
Oh,
let's go to
fuck
after
you.
that,
Come on,
2:52:00 to 2:52:34.
Just yesterday. Because of how it's been lately. Like since Australia. And I have been on the road with you. I haven't been working. I don't know what else I could fucking do.
Since Australia, you've gone on a honeymoon. You had a great time other than the fact that you had a fight on each other.
Yeah.
Physical.
Yeah.
Then we had a
Again.
fight in San Francisco. But I thought everything else
What
was
does this
great.
show?
I'm doing this since Australia.
No.
And then let's go to 3:20:00.
Can we not
To
just play the
3:21:37.
3 minutes of audio? We gotta bounce between 20-second clips. Like
Yes,
what's
apparently.
between them? This is where you could object
While
on the
they're
rule of
getting that,
completeness and have them
I'll
play
just ask you
the
the question, Dr.
thing
Hughes,
straight
do you
through if you
recall that Mr. Depp said that they had fights in the places that he listed on that audio tape?
Objection leading.
Sustained.
All right. What do you recall Mr. Depp saying?
All right, we're gonna move on to something else. But this is just a little bit of a snippet of what's been going on in this case. So there is finally some news, some good news. I don't know if you guys remember when I needed to renew my health card and I was going through all sorts of bullshit with that. Because I couldn't renew it online because I didn't have a driver's license number. And the Service Ontario's answer to that was, well, just have somebody else fill out the forms for you. Because apparently disabled people / seniors or whatever don't have agency and they need somebody to do it for them. Well, finally, after 2.5 years of the CNIB doing lobbying and stuff, they've actually done something correct here. This is a story that I just found on Facebook yesterday, so I saved it. And I figured I would read it to you guys because I know I was bitching about the ordeal of getting my health card renewed. So I figured I would share this with you. So this is, what is this here? Ontarians can now renew their health card online without a driver's license. Thank God. On May 3rd, 2022, it has been more than 2 years since CNIB first alerted the Government of Ontario that people who are blind, partially sighted, or deaf-blind were unable to renew their health card online through the Government of Ontario website because the renew form required a driver's license number. It does, or it did. Like, it would not allow you to continue without a driver's license number. There was no checkbox that said, I have it's called the Ontario photo card, and it is literally, it's basically a driver's license without a driver's license number. It is government ID. It gets you into anywhere and everywhere that requires ID. It's just not a driver's license, and you couldn't use it to renew your license or your health card. After many discussions with the Government of Ontario and powerful advocacy from the CNIB and other disability organizations, Ontarians without a driver's license can now renew their health card online using an Ontario photo ID card. Finally! Holy shit! Like, and I tweeted at them, and I made a couple of videos about it. It was very frustrating. I'm very happy that this is finally a thing. This is awesome. Thanks to the advocacy of people with disabilities, including sight loss, the Ontario Photo ID card was introduced in 2011 as an alternative photo identification for people who do not have a driver's license, making it easier to do such things as open a bank account or other things that require official identification. Yes, because although this there's a card that's called the CNIB card, and it was supposed to be recognized as ID, but a lot of places you had to bully and badger them into recognizing it. It would not, when I was in university and was trying to apply for Ontario Student Loan Assistance Program, they refused to accept my CNIB card as identification, made me get a photo health card, and made me use that as ID, even though health cards are not supposed to be used as ID. It was bad. And I was like, would you do this to a person with a native status card? And they're like, well, no. And I'm like, then why are you doing it to me? It was rather ridiculous. So I'm very glad that this has changed. The government previously extended the deadline to renew an expired health card until September 30th, 2022. Wow. Ontarians will continue to be able to use their expired health card, including red and white health cards, to access insured healthcare services until the September 30th, 2022 deadline. CNIB continues to work with the Government of Ontario to ensure services are accessible to Ontarians with sight loss from the outset. Earlier this year, we commissioned a research project on the accessibility of Service Ontario services, and we completed a series of focus groups with Ontarians who are blind, partially sighted, or deafblind. So yeah, that's good news. I'm very happy with that. The CNIB has been kind of a dead weight organization for a while, and it's good to see that they've done something right. It's high time. So I'm very glad to see that. All right, let's move along to our next story. So I'm going to go for a bit of a rant here because my Twitter feed has been full of blue checkmark Americans freaking out about Roe v. Wade being overturned, and it hasn't even there hasn't even been an opinion. All it was a leaked memo from a judge going, "Hey, maybe we should look at Roe v. Wade." That's it. There's no opinion published. There's no firm, verified yay or nay on whether it's being overturned. And everybody is losing their shit. And it's coming up here. It's coming up here. And it's ridiculous. And I'm going to show you what I mean. And I don't understand. How can people not be dropping dead of coronaries from the overreacting that is going on? The amount of overreacting over everything that has been going on for the past 6 years. I do not know how there hasn't been a huge influx of just people dropping dead of heart attacks from just stress caused by overreaction. I don't get it. I don't understand this heightened sense of we have to be on this state of constant, oh my God, everything is going to end. I don't get it. So this headline says, U.S. Supreme Court abortion law leak puts focus on conservative candidate abortion views. Oh, for fuck's sakes. For fuck's sakes. This is just crazy. So this was published May 3rd, so yesterday. And yeah, let's see here. A U.S. Supreme Court leak indicating a reversal of the landmark Roe v. Wade ruling is prompting a Conservative Party of Canada's leadership's candidates to publish their stance on abortion. What indication of a reversal? What indicate? The memo didn't say, hey, we should think about overturning Roe v. Wade. It just said, hey, we should look at Roe v. Wade. That's it. Even if Roe v. Wade is overturned, HIPAA is still a thing. Yeah. Yeah. Exactly, Duck Dog. The draft opinion is reinvigorating. I thought it was a memo. I'm pretty sure it was a memo, CTV. The draft opinion is reinvigorating the debate that is often part of the leadership race discourse, bringing light internal policy divisions, of course. 3 candidates, Pierre Poilievre Leslyn Lewis, and Scott Atchison, all sitting members of Parliament, have all been advised by interim leader Candice Bergen not to speak to the draft opinion as it remains before the U.S. courts. Nobody should be speaking. Nobody. Because it's not an opinion yet. It's not a thing. And it's not even if it becomes a thing in the States, okay, guess what? We are an entirely different country with an entirely different fucking government system. So why does it matter if the states are doing something? Okay? If the fucking Americans jumped into the fucking Challenger Deep, should we follow? Jesus Christ almighty. What the hell is wrong with... Ugh. This is so annoying. Where is the Matt Christensen video about... Can you... Or, no, you're driving. I don't think you can send it to me. But god damn, this is frustrating. Nevertheless, Atchison released a video about the developments. Of course, because, nobody can keep their goddamn mouths shut. Nobody in the States can keep their mouths shut. Nobody up here can keep their mouths shut. Jesus Christ. Okay. Special, wait. Where am I here? Why are there so many links? There will be many who say this is an American issue, but the blunt reality is that all too often the political discourse we see becomes part of our politics too, he said. Because we let it! We let it! We let it become a part of our political discourse because 70 to 80% of the news channels that are up here are fucking American. So maybe if that changed, and maybe if our journalists were a little less fucking insane, then maybe American issues wouldn't become Canadian issues. Just a thought. Just a wee brain idea of mine. Atchison said Canada must do better to cool the polarizing rhetoric present in the U.S. and act with respect and empathy when dealing with contentious issues. You mean, a common sense thing? In other words, shut the fuck up? He then went on to say he defends a woman's rights to personal choice to all women's reproductive rights or health services. Let me be clear. I will ensure that women will have access to the resources they need to make their own informed reproductive choices and to be informed, he said. CTVnews.ca received a statement from the Lewis campaign, noting she won't comment on the documents as they don't represent a final decision, but reiterates the candidate's pro-life agenda. Meanwhile, Jean Charest tweeted out that he is pro-choice. A government under my leadership will not support legislation restricting reproductive rights. Well, I respect blah, 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 blah. Everybody is saying, well, this is a U.S. matter. I'm still going to be a political shill and reiterate that I am pro whatever I am pro. Just shut up. Oh, it's so frustrating. Let's try and find the Matt Christensen video. Let's see. Let's try and find it. Let's see. Let's see. There it is. What video is it? Yeah, what video is it, honey? I don't see which one it is. I do not see which Matt Christensen video it is. I am not, yeah, it's gotta be recent. It's gotta be recent, because this just happened. Where is it? No. No. That's 4 days ago. Latest from Matt. Yeah, I'm subscribed to him. Oh, understanding the case. Okay. That's what this one is. That's the one. I found it. I found it. Okay, I found it. So let's watch this. I hope Matt doesn't mind. I hope he does not mind that I am watching it. But okay, let's get this shared. Oops. I like Matt Christensen. He's got a calm way of presenting stuff. Oh, I need to apparently stand up. Ow, my legs are yelling at me.
The overturning of Roe versus Wade was always destined to be a political mess,
Of course.
even if it is a necessary one. No matter how it happened, it was always going to produce incoherent screeching from people who did not read this decision and have never read Roe and have never read any of the cases preceding Roe that
Yep.
Roe claims to be based on. So no matter how clean the reasoning of the opinion to do it, no matter how compelling the legal argument, the true believers are loyal to the concept of abortion itself, not to the Constitution or the process to decide that issue.
Oop. And that's exactly that's my point. That I'm like, not only am I upset that everybody is shrieking about something that hasn't even been published yet, most of the people that are shrieking about it don't even understand what it is about. We had to study Roe versus Wade in law class in high school. And I do vaguely remember it. I don't remember the whole thing, and I do not remember it in depth. But I do remember studying it, and I do remember thinking that this law kind of did go against the US Constitution. So, I mean, if I could figure that out at 16, I'm not sure why these people are having such a hard time with it.
And so any opinion counter to that highest value was always destined to be met with hostility. But it certainly didn't have to be this messy, though. There is a terrible irony that we're replacing one stain on the Supreme Court's history with a brand new stain on the Supreme Court's history. Assuming this report is correct and Roe is destined to fall, we are replacing one of the court's worst all-time decisions with one of the court's worst all-time betrayals, the leaking of a draft opinion. According to Politico's story releasing the draft, a leak like this has never happened in the modern history of the Supreme Court.
I was actually wondering how this even happened, because I've never heard of a leak from any Supreme Court, from either American or Canadian Supreme Courts. I've never seen I've seen news releases saying this opinion is about to be published, and the decision is on this case, that whatever, but I've never seen a leaked opinion from either the American or the Canadian court.
Other stories note that certain details of some cases, including the original Roe v. Wade decision, actually have leaked to the press before official decision publication. But in those cases, the actual draft opinion wasn't published early as it was in this case. This is effectively a never event, and we don't know who did this, but it's fair to surmise it's for the same reasons that the activists won't read the actual opinion anyway. To whoever did this, the outcome is more important than the process. And so even if the entire legal system is a casualty of their outrage, well, so be it. And that is
I didn't look at it that way. A person on the inside who just kind of wants the whole thing to burn. That's an interesting way of looking at it. I didn't quite think to look at it that way.
is not an exaggeration. Consider the severity of the consequences. It's also fair to infer that the intent of the leak is to intimidate justices, to get them to see the outrage and then to change their minds in fear of the outrage. And even if they do withstand that fear, the trust between the justices and their offices will now be severely damaged.
That's another good point. The judges don't know who to trust now. They don't know if one of their clerks leaked it, one of their clerks leaked it. Did a sneaky bailiff get in there and leak it? Did a janitor do it? There's that's a very good point.
How is a justice supposed to write and vote on opinions honestly, knowing that his colleague may take that information to the press tomorrow to get him? If we all claim to agree that politics must stay out of the court and the court must remain a house of the law,
Yes.
then we all should agree that this sort of leaking has to be investigated and ended, because it necessarily
Absolutely, it needs to be investigated and ended. And the person that leaked that opinion needs to be punished severely. That is not a thing. Like, you do not need to fuck around with the Supreme Court. The Supreme Court is supposed to be an independent judiciary body that is supposed to be one of the checks and balances in place for both of our country's governments, honestly. And if you have something like this, you are compromising that. And that needs to be dealt with swiftly and very harshly.
injects politics into the court. The purpose of the leak is to politicize.
Yeah.
It's not immediately clear that the leaker actually broke the law, at least purely by the leak itself, though depending on how the information was obtained, there could be a computer hacking crime or some other tangential crime. But criminal or not, the court is well within its rights to police its own, to find out who did this, and to hold that person accountable to the maximum extent possible, as the Chief Justice is now promising to do.
If this causes the kind of violence that I have seen called for on Twitter, I would argue that once this person is found, and this is from a very rudimentary understanding of the law, mind you, I would argue that they may be able to prosecute on domestic terrorism. But I could be wrong. But the reason I say domestic terrorism is that publishing this leak is very clearly political. Very clearly, somebody is trying to use the Supreme Court, a body that is supposed to be completely apolitical, and using them as a political pawn in a bigger thing, which that is why I'm saying you might be able to push for a domestic terrorism charge if you were an ambitious prosecutor.
Which also creates an interesting political dilemma for the president. Of course, Biden has advertised himself as the man of unity, the man of loyalty to our institutions and systems over partisan political differences. Well, not only rule of law principle, but his own branding should compel him to deliver a condemnation of this leaker and a pledge to help find this leaker in pursuit of accountability. But of course, if he does, he'll be viewed as a traitor on a priority progressive issue. So what wins? His commitment to unity and to principle, or his bending over to fringe progressive activists? And I think we all know the answer, so I guess this dilemma isn't actually all that interesting after all. Before I could even finish this video, Biden had already...
Committing fraud against the government is a federal felony, and breaking the NDA, somebody's guilty of that. Yes. Yes. Yeah, that's very true. Because you can't, there has got to be some sort of NDA that you sign when you go to work at the Supreme Court. I would be supremely shocked if you did not have to sign something that says, I'm not going to talk about what I see at work. I'm not going to talk about what I hear at work. I'm not going to talk about the cases that are being heard. Like, there has got to be something like that.
Already caved to the politics.
The idea that we're going to make a judgment that is going to say that no one can make the judgment to choose to abort a child based on a decision by the Supreme Court, I think goes way overboard.
While also getting...
Wait, what? You're So wait, you're not going to wait, what? You're not going to listen to the Supreme Court? I'm confused. Now, part of that is because when Joe Biden talks, he doesn't make any sense. But let's see what he just said, because that made no sense.
Already caved to the politics.
The idea that we're going to make a judgment that is going to say that no one can make the judgment to choose to abort a child based on a decision by the Supreme Court, I think goes way overboard.
Well,
Okay, so he's basically saying that we're not going to listen to the Supreme Court. And he's also saying that if the Supreme Court overturns Roe v. Wade, that means that there is going to be no decision, that abortion, that we are immediately going to go back to horrible coat hangers and eating freaking herbs in your bathroom and like, ugh. Whoever did this is going to jail, trust me. Oh yeah. You think you're confused? Biden is truly confused. Yeah, he sounds confused.
also getting the politics totally wrong, of course. The court's pending opinion does not say that nobody gets a decision on abortion. It says the decision is properly reserved to the states and to the people, not the court by made-up decree. Leave it to Joe to get the point exactly backward. And it's pretty important that we get that point right. It's not to diminish the importance of the other points, the moral weight of the abortion question itself, the importance of institutional integrity and a president who will stand up for it, even when his politics lose the day. But the point that Joe misses from a legal perspective is actually the most important one. And unless we pay attention, we might miss it too. It becomes a casualty all but silenced in the rest of this noise. Roe v. Wade is among the worst decisions in the court's history as a matter of law, not as a matter of your personal abortion opinion. Stuff you like doesn't make a Supreme Court decision good.
Exactly. Do I like that I can go buy weed from a dispensary? Do I like that? Yes. Do I like the way that weed has been legalized here and some of the restrictions that are imposed on how it went about it? No. I think it was absolutely stupid the way it was done. Just because I like weed doesn't mean I like the way that it was legalized, right? Whether you like or dislike something doesn't make it a good or bad law. It's legal technicality and correctness or incorrectness make it a good or bad law. That's all. Like, you know what I mean? Like, that is all that it is. It doesn't matter whether you like abortions, whether you think you should have a right to an abortion, whether it was well constructed or not, makes it a good law. That's it.
Fidelity to the law and the Constitution do, and there is no coherent legal argument in favor of Roe. It was made up nonsense then. It remains made up nonsense today. And this leaked opinion from Alito explaining that point is excellent and well written. So, of course, it will not be well read nor well publicized. Instead, we'll hear it characterized as some sort of anti-abortion or anti-women rant. But of course, it has nothing to do with the wisdom or the folly of abortion policy. It has everything to do with who holds the right to make those decisions as a matter of law, not as a matter of the personal preferences of the bench. The reason to know this leak is authentic and not some fake is not just because the Chief Justice, John Roberts, has now confirmed its authenticity. It's because it's an argument so thorough and thoughtful, using language Alito has previously used in a way that only he could write it. The opinion is quite long. It's nearly 70 pages of argument, 30 more of appendix material. It is very clear reading it that Alito has been rubbing his hands for a very long time in anticipation of this opportunity, but because it's one that he takes seriously. So it's an argument that he makes comprehensively.
So it's well thought out, it's well researched, it's well backed up by case law, which is, I'm guessing, what all those appendices are, on top of the 70 pages of opinion. So Alito has not been just he's not just going, abortion is bad, okay? He's not doing that. And that's what these assholes are, these disingenuous people. And honestly, some of them truly believe to their core that that is what he's doing. Okay, that they do not understand that Alito is not saying fuck women. They all should be forced to bear children from their rapists and be forced to die from a fallopian tube pregnancy. No, he's not saying that at all. He's just saying that this particular law is badly written and it needs to be looked at. That's it. And these people are just...
And he could have been much more simple and just written, abortion isn't in the Constitution, lol, GTFO. But he didn't. Instead, he gave the pro-Roe side as much credit as possible, though he didn't have to. He steel-manned their case and still demolished it in crafting a decision that is all but inarguable legally. His argument should be credited for its good faith and its intellectual honesty and rigor, but of course it won't be. It'll just be smeared as some sort of ideological attack without any textual reference, of course. So let's give his text that proper reference and consider his argument. He deserves that consideration as he extends it to others, and any honest opinion about whether he's right or wrong requires as much anyway. Alito
you can't make an honest opinion on anything if you haven't absorbed the thing that you are making the opinion on. You just can't. It's like that when it's the Family Guy episode when Brian met Rush Limbaugh, and Rush Limbaugh was like, have you ever read any of my books, Brian? Because Brian was giving Rush a whole bunch of shit, and Brian goes, no, I have not, but I have read things that people have written about your books, and I do not like what I have read, sir, not one bit. And that's exactly what these people are doing. They are regurgitating third-hand knowledge of this opinion.
Begins with how we evaluate what are and are not constitutional rights. Of course, there are the obvious enumerated ones, the ones explicitly mentioned in the document, your First Amendment speech rights, for example. And then there are unenumerated or implied rights. Think your right to a presumption of innocence. It's not explicitly stated in the Constitution, but a concept of due process in a court of law requires it. If we presume you guilty, the entire concept of due process is reversed. Yeah. Nobody argues that abortion is in the Constitution's text because it isn't. So the argument is that abortion is an implied right. Alito doesn't necessarily have to entertain this argument, but he does, and he thoroughly explains why abortion is not, in fact, constitutionally implied. First, because Roe's right to an abortion is not any sort of direct implication from the text itself. Yeah. It's an implication of an implication, and a weak one at that. Roe claims the implied abortion right is derived from the implied privacy right, without explaining, even if we grant that privacy is an implied theme of several constitutional provisions, how abortion fits into that concept any more than murder or other crimes do. And of course, Roe didn't stop at just making some double implied inference on an abortion right. It prescribed an entirely made-up regulatory framework, too. At the time, it was the trimester rule. States could not regulate abortion in the first trimester. They could in the third, and there was a mess of this but not that allowed in the second. Bizarre specifics which certainly have no basis in the constitutional text, achieved only by several leaps away from it.
Yeah, how does abortion and privacy go together? I have the right to have an empty uterus. Like, this uterus is this. I'm sorry, this uterus is members only, and I'm the only member, and I'm not even inside my own uterus. I just carry it around. But it's like I said, it's a private uterus. I only wish myself to have access to my uterus. Thank you very much. Like, what privacy does abortion? Like, I would have thought it was. I honestly thought it was predicated on the freedom aspect, which I would have had a bit more ease of believing. But privacy? Nah, fuck that
Even
shit.
if we grant that rights exist by implication, Roe goes well beyond that and says specific regulatory framework exists by implication.
Yeah.
Of implication, there has to be some sort of limitation on such reasoning. And there is. Not just what Alito says is the limitation, but what Supreme Court precedent does. For all this talk of loyalty to precedent, Alito is loyal to precedent. We have objective,
he's loyal to
established
the wrong
criteria to
precedent,
define
yeah.
what implied rights are. In addition to a textual basis in the Constitution, implied rights are deeply rooted in American history and tradition and are fundamental to our scheme of ordered liberty. Again, according to Supreme Court precedent, not according to Alito. In the case of abortion, the history and tradition isn't just absent, it's the opposite, actually. The history and tradition is of criminalizing it. At the time of Roe's decision in 1973, abortion was illegal in 30 states in all situations but for threat to life of the mother.
Yeah.
If you want more history than that, in 1868, when the 14th Amendment, the alleged basis for this right, was ratified, 3/4 of states criminalized abortion, as did the territories. If you want more history than that, abortion was criminalized in colonial America. If you want more history than that, abortion was criminalized under English law dating back to the 1300s. And nobody argues this point. Not the abortion clinic bringing this case, not the briefs submitted in their support. Nobody can show that abortion has been a historical right. And if you don't have that history, you don't have the evidence that precedent demands to find an implied right in the Constitution.
Yeah.
Or at least you don't have one of the ways, but recall, there is another. Perhaps you want to make the argument that abortion is a right fundamental to our constitutional scheme of ordered liberty, as precedent allows. One, it's hard to make that argument without any supporting history. Did ordered liberty not exist prior to 1973? Regardless, to Alito's argument, what does our system of ordered liberty mean if not for the rights of the people in each state to decide contentious issues and balance competing interests for themselves? How does ordered liberty mean 9 unelected justices get to usurp power from the people and seize it for themselves? Okay, but what about all the other rights? The critics may counter. If you erase this right, what stops you from erasing all the other implied rights? Alito considers this concern too, though again, he doesn't have to. He does it to be thorough. As discussed, valid implied rights meet 3 criteria. They have a textual basis. They have a historical tradition. They have some fundamental function in our system of ordered liberty. Abortion does not meet these criteria, but abortion is also unique in another way. Alito notes, by Roe and Casey's own descriptions, it is the termination of life. It carries with it that inherent weight and that inherent threat of permanent injustice. Injustice for your marriage rights can be reversed. Yes. Injustice for your procreation rights can be reversed. Yep. Injustice that costs you your life cannot. You're gone. For these reasons, Alito states explicitly, this opinion overrules the supposed constitutional right to an abortion only and no other right. Oh, but it's precedent. That's the last stand of the activists. You can't.
Oh, but see, precedent only matters to them on this particular, like in this instance, right? When it comes in their fear of losing what they consider to be a right, even though you can prove that it's not a right, they're going to yell precedence, precedence, precedence. But when you say to them, where is the precedence that abortion has ever been a right? Oh, well, that's not necessary. Well, okay, but then why is it now precedence if I set this law? Oh, because I said so. It's very hypocritical of these people.
Can't overturn Roe because it's established and settled and it's history. Well, one, we actually have more post 14th Amendment history in which abortion was criminalized, not legalized. But two, and more importantly, surely precedent isn't locked in forever because bad decisions do get made. And Alito again gives this point a full good faith precedent-based argument too. If we agree that it was correct to overturn Plessy versus Ferguson and the separate but equal doctrine, among other bad precedents, surely there are standards for when overturning precedent is appropriate and correct. And again, according to precedent, not according to Alito. Alito is following precedent in justifying overturning Roe. Alito outlines 5 justifying factors used in prior decisions to overturn cases. The nature of the error is the first consideration. What anti-constitutional consequences has the case created? In Plessy, it was denying equal protection. In Roe, it's revoking a question of profound moral and social importance from the people. Roe short-circuited the democratic process by closing it to a large number of Americans who dissented. The quality of the reasoning is the second consideration. As we've mentioned, it's reasoning with no basis in text, history, or precedent, but it fails even basic logical standards. Roe and Casey established a viability standard in which the child has a right to life once it's viable or could survive outside of the womb. But that standard isn't even consistent. Viability varies by child.
It
varies by mother.
It varies by child, varies by mother, varies by mother's care of herself during her pregnancy. It varies by her environment. It varies by her access to medical care. It varies by so many goddamn things. And it's just, this is why I loved taking law class, because I loved like reading these types of judgments. Hey, Gunny. I'm almost done here.
Varies by technology and proximity to that technology. It's a standard that changes every day and is different for different people, which means it is no standard at all. And on the remaining considerations, Roe fits precedent established criteria for overturning a case as well. On workability, as in whether the standard can be applied in a consistent and predictable manner, Roe and Casey's standards aren't. Viability varies, and the standard Casey established to prohibit undue burdens against obtaining an abortion is inherently standardless, as Scalia wrote, because the court gave no definition to what is undue. It is a completely subjective judgment. Indeed, it was a subjective judgment among the justices on that court at the time. In that case, Justice Stevens thought the waiting period at issue was undue, and the rest of the justices did not. Uncompromising the court's other decisions, another qualifier to overturn based on precedent, Roe undid the formerly strict standard for constitutional challenges and created a court that can simply invent outcomes it likes rather than the outcomes the law commands. And lastly, there are no reliance interests that precedent demands be considered before overturning. By its nature, abortion is not a planned activity, or at least Alito concludes that by perhaps giving these people too much credit. What remains of their sanity might actually rely on their lust for an abortion, but to Alito's point, that's really more of a them problem than a Supreme Court problem. And Alito's still not done. You have straws to grasp, and he has a gavel to swing, but he does the nice thing by listening and answering in good faith anyway. But women are going to be subjugated now, we'll surely hear screeched from under the Handmaid's Tale costumes. How?
Yep.
In Mississippi, the state that passed the abortion law in this case, women outvoted men by a 10% margin in 2020. It's a trend that's...
Women are very... I have noticed that there are a lot more women that are against abortion.
True nationally, too. Women outpace men in both voter registration and turnout. Unless that decades-long trend suddenly changes, whatever reaction happens to this case will be the result of women's political power, not the lack of it. Well, what about institutional integrity, the critics may ask? Hasn't the court just undermined its own trust? Well, how does the court earn trust, Alito asks? The court earns trust with strong, constitutionally faithful opinions, not raw judicial power exercised at the expense of the people and their states. And that is a very long tour through a lot of details, I know. But the point is, Alito is not cramming down some ideologically driven dictates as he'll be accused of. He has listened carefully to all of the arguments. He has considered them, and he has explained the principles that compel the court to return this issue back to the people to decide. It's a completely considerate decision, not a dismissive one. Alito gave these activists far more kindness than the point and laugh that they deserve. But because Alito is so thorough, it can be difficult to summarize the substance of the argument briefly. So let's do that to understand it and to invite the rebuttals that won't come because they're all but impossible to make with any fidelity to the law. Number one, abortion is not an enumerated constitutional right. Number two, abortion does not meet the established criteria for identifying rights implied in the Constitution, those being a textual basis, a history and tradition of the right, and the right being fundamental to our scheme of ordered liberty. Number three, therefore, the Constitution is silent on the issue, and where the Constitution is silent by the explicit constitutional requirement of the 10th Amendment, the issue is properly reserved for the states and the people within them to decide. Screech all you want, but those pillars of Alito's argument are as bomb-proof, text and precedent-based as it gets. It's why we'll hear little of an actual argument against it. Instead, we'll just get generic smears and mischaracterizations without actual reference. They don't read it because they don't care to. As simple and solid as Alito's argument is, theirs is much simpler. I like abortion, therefore abortion is a constitutional right because stuff I like is more important than the rule of law. Good luck maintaining a country according to such subjective, standardless nonsense. The maintenance of the country depends on the maintenance of the states and the proper reservation of power to them. Assuming this decision is actually finalized in the near future and Roe is actually overturned, it will be a big win for that constitutional principle. And better yet, it's a big win for the states in another big way. Maybe now these people will finally stop moving to ours. California is doing their damnedest to keep them. Please come back. We'll pay your expenses to be an abortion tourist in our rotting, godforsaken state. Just give it a couple weeks, and they'll be offering an all-inclusive Disneyland abortion package. Just watch. And if any of that is even remotely appealing to you, please take that deal. We just can't compete with that sort of extravagance here in flyover country. We're just a bunch of simpleton rubes who cherish our right not to. Thanks as always for listening.
Oh, Matt is great. I love Matt Christensen. He's awesome. That was a great video and a great breakdown of what's going on. And it just reinforces why I get so annoyed with people up in Canada who are freaking out. I'm like, it has nothing to do with us. Nothing. Like, come on. We have a totally different system up here. And healthcare is provincial anyway. Like, what? Oh, people are so stupid. Anyway, I need to go have lunch. And I hope you guys enjoyed this episode. I will be on Twitch in the morning tomorrow before I go to the gym. And there will be a coffee stream on Friday. So look out for that. And this Saturday in Discord, we will be watching A New Hope for our movie. So I hope you guys have a good day. Thank you for watching, and I will see you later. Bye.